We'll hear argument next in Case 09350, Los Angeles County versus Humphries. Mr. Coates.
Mr. Chief Justice, and may it please the Court. In Monell versus Department of Social Services, this Court held there could be no liability against a local public entity under Section 1983 unless the plaintiff proved causation, namely that the injury that was inflicted as a result of a custom, policy, or practice of that local public entity. The Ninth Circuit, however, in this case, has imposed ex post facto declaratory relief on the County of Los Angeles as well as a substantial fee award, while acknowledging that it has not, in fact, determined whether the injury suffered by the plaintiffs and subject to the declaratory relief was the result of a policy, custom, or practice fairly attributable to the County of Los Angeles. It did so because the Ninth Circuit has developed a digression from the Court's jurisprudence in Monell. Namely, in the Ninth Circuit, claims for prospective relief, both injunctive and declaratory relief, are not subject to the Monell requirements. We submit that this is flatly inconsistent with Monell and erodes the important principles of federalism that are the motivating factors for the Monell causation.
What was the basis for that exception, that declaratory judgment does not affect the fisc of the?
Yes, essentially. In the
it does, though, if you have attorney's fees. What was the total attorney's fee award in this case?
As to the county, it's $58,000, but the overall award is far above that, and that's just for appellate attorney's fees. We're not even talking trial fees at this time.
What's far above? Like what? I suspect
$600 and some odd thousand dollars.
The case is mostly about attorney's fees.
But there was no objection on the part of the state. The state was to pay the lion's share of the fees, I think 90%, right?
Correct. The state is not contesting.
And the state is not contesting.
The state has not contested that, correct.
Does the state make that payment under an ex parte Young theory?
Yes. It's a suit against the state under ex parte Young theory, since they maintain the statute.
If you sue the municipality, they denied marriage licenses. Do you have to sue under 1983, or you can just sue alleging a federal cause of action because of a denial of a constitutional right?
Well, it would have to be under.
It would be like a Bivens action, I guess.
It would have to be, the courts recognize, against local municipalities' liability under Section 1983.
The only way to sue a municipality for a constitutional violation is under 1983?
In a direct civil cause of action, I believe that is correct.